An Introduction to Legal Skills, How to Think Like a Lawyer, Module 2, Facts. 2.1, Sources of Facts. Now please remember to use your workbook as we go through this discussion. Well, first of all, where do we get facts from? Now we're looking at this from a legal point of view. We're looking at this in the context of labor relations, which is generally around disputes that happen in the workplace. So, one of the sources of facts is if you're a representative of a party in a hearing or arbitration, somebody, a client, I say client could be a member of your union, that kind of thing, comes to you for advice. And they tell you what happened. So what we do is we consult and we investigate. We ask questions and we probe until we're able to understand what happened. Usually, this is from a client or member's point of view of that particular incident. Right, so that's one way that we get to hear what facts are, or the sources of facts. Another way is a preliminary or forensic investigation. Right, now let's start with a forensic investigation. A forensic investigation is where there are experts in fields like accounting, and they will do what they call a forensic investigation to investigate the accounts of a company or organization in order to investigate if there was fraud, that kind of thing. Not only accounting, but various other types of almost specialized people will come and have a look and investigate what has taken place. A preliminary investigation is something that I have a course on of how to do that, but basically what it is that before you proceed down the track of charging somebody, holding a hearing, going all that, you investigate the facts of the matter. You find out there's an allegation that somebody came to work drunk. You don't just jump in, you check out, you ask facts, you check if there's any evidence to support that, and so on. So that's a preliminary investigation, which is done before we move into the sort of more formal processes in labor law in South Africa, which is the disciplinary hearing and arbitration. Well, then if you chair a hearing or sit as an arbitrator in that more formal process, now you'll get versions of an incident by witnesses. Now you'll notice I'm talking a few times about versions of an incident. So that's what we need to, just bear with me for a little bit. Okay, we read a finding, and I'm trying to pass on some important words here as well. So a finding of a disciplinary hearing, that is where a chairperson has written out their what we call a finding. Okay, when there's an arbitration award, different thing, same if you like, it's in writing, etc., etc., but we refer to that as an arbitration award, or a judgment in a court case. Now those would then be in writing, and we can learn from what has happened in the past by reading those. Okay, so the first few was verbal statements made by people, versions of an incident. Then you have the written judgments and that kind of thing. So these are all versions of an incident. And what we'll see is that there are a number of versions of an incident. Okay, now that shouldn't be surprising. Think about something happens at school place or at university or something like that, where a number of people are present. What you will find is that each person who was present will give their version of what took place. And sometimes those are biased versions. Sometimes they're just partial versions because they didn't see a lot. Sometimes they are accurate, depending on a whole range of things. The point about this is that there are versions of incidents. So that's part of the learning here, is to understand that we don't just accept one person's statement. We need more than that. that shouldn't be surprising, because in life that's what happens. So something might happen at home, you have a version, and your husband or wife has a different version of what took place. Within the same sort of situation, kind of same facts, but different versions. Okay? So don't be surprised by that. We're just applying what happens in life. But now, because there are a number of versions of an incident, each person seeing from their own point of view, we need to find out which version is more probable than the other version. Okay? So I'm teaching you words here, or phrases: finding, award, judgment, preliminary investigation, forensic investigation, and so on. So you actually need to remember what this is about from that point of view. Okay, so we've got this question now of more probable. Now we're getting into some, you'll see later, interesting, and sometimes, interesting law. All right. So now we find which version is more probable than the other. And to do that, and because we need to find out which version is more reliable than the others, we talk about a balance of probability. Now, I'm going to unpack all of this in more detail, but to understand, give you a brief introduction, particularly if you've never come across these kind of ideas before or notions, a balance of probability. Basically what we're doing, we're saying, here's one version and here's another version. Yes, the car was driven into the wall. And this one is, no, the car did not drive into the wall. The brakes failed. Which version is more probable? How do we work that out? We talk about a balance of probability. On balance, which version is more probable? Very important aspect of understanding facts and how we assess it, how we use it, and so on. But there's more. The trouble is that because of these versions of what took place, what we find is that, and because we need to find which version is more reliable, more probable, we need to talk about which is relevant. So, again, not too surprising, but you need to think about it. You have somebody saying this is what happened, and when they tell the story, they're telling you all sorts of things. The history of the matter, how they felt, how they wada. And only part of that is actually relevant in terms of what you can actually use, as you see later, as evidence. So there's the term relevant. But relevant to what? When I say relevant, what are we talking about? Well, the issue and dispute. So what is the dispute about? Is the dispute about whether the brakes failed, or is the dispute about whether the car actually hit something? What is the dispute about? So it might be relevant to what some facts, some version might be relevant about the car hitting the wall, and other might be relevant about the brakes, depending on what the issue and dispute is. So what we do is we focus on facts that are relevant. Now, just to give a little, there is on the website, you'll see the law of evidence, and the very first introduction to the law of evidence unpacks the question of relevance in a lot more detail. So I'm giving you a little taste here of making to understand the phrases, the words that we use. This is all part of understanding law. Okay, you can't talk about facts without talking about relevant facts. You can't talk about law without being assessing facts about which is more probable, and so on. Okay, so we need to know relevant facts. To understand the processes that we are talking about within the context in labor law, we have processes like disciplinary hearings, you may have heard of that, and arbitrations, you might have heard of that. But what we need to understand is those processes are primarily fact-finding processes. So in a hearing, it's to find out, as a matter of fact, did the brakes fail? All right? Or not? Or was there some other reason why the car went into the wall? But the process is geared at finding facts. As is a disciplinary hearing, very important to understand that both of those, that's really what they are about. That's why, the facts are important, the key. Now I'm going to make it, I'm making it almost too simple here, but I don't know how to make it, to get it across without making it, in a sense, too simple. Because I'm saying here, facts become evidence once they've been tested by cross-examination. So, in a sense, we have facts, versions, and some of that version is relevant to the issue and dispute, and other to, or it was not relevant. Now, those facts, the relevant facts, become evidence, but they need to be tested. In other words, what you're doing, you're putting one version, or maybe more than one, but one version against another version, and seeing which is the more probable. And that process happens by way, primarily, not only, by way of cross-examination. And cross-examination is not cross-examination, it's asking questions around the different versions, putting one version against the other and seeing which is more probable. We've also learned that documents are sources of facts. So we've covered a lot like the verbal person's version, verbal version, etc., etc. Statements that become evidence through cross-examination. But documents are also sources of facts. So what we will learn is how to skim a document. For example, case law. So that in itself is a very important skill that you will need to practice, to understand, and then practice through this process to become quite efficient in it. Example is case law, because we'll look at case law to find the parts of a case law that are relevant to the particular issue and dispute that you might be dealing with. So you'll, for example, and that's what I say, if you look at the course on conflict of interest, for example, where the law is set out in the article, and I discuss it. What we're looking for is facts first, and then the issue is there a conflict of interest? How do you prove that? What evidence do you need? And that kind of thing. So to do that, often there's documents that you need to look at, but not like school, where you're given a document and you're told read the whole thing. What I will show you, it's almost impossible to do that in law because there's so many documents. What I will show you is that there's certain parts of that document that is what you're looking for, not the whole thing. So I'll teach you to find that particular, what we call skimming a document, and case law in particular. And then there's this question of researching. Okay, researching case law. So with documents, researching case law to find the correct law, and again, correct is not entirely correct, but anyway, the appropriate law, applicable law, and then find case law that assist us in the dispute we're involved in. Now, all of that we're going to deal with. So, to an extent, I have given you here a very short unpacking of a whole, if you go to law, do your LLB or so on, this is almost a year's worth of learning. But if you're touching on this and you start to understand what this is about and how it all fits together, it'll help you tremendously in learning, learning the skills that you need for labor law, and of course other forms of law. This applies to other laws as well. Okay, so you're going to research case law, find the appropriate case law, and we'll look at that as part and parcel of what we're doing. Okay, we're going to move on now to 2.2,